So once again, welcome. Thank you for coming. And without further ado, I'm going to turn things over to the moderator of our first panel, Professor Chris Holman.
Great, thank you. So I'm going to forego any long introductions of the panelists. You can look them up online if you want to learn more about them. So I think we're just going to launch right into our panel on new shifting business models with Jonathan Barnett.
Thank you. Well, I'd like to start off by thanking CPIP for the opportunity to speak to you today. Some of my recent work has been empirical work looking at data on patent licensing markets. This paper kind of takes a big picture view to draw out some policy implications from that work. And I'm going to be talking about something that perhaps we could call a meta business model, kind of an umbrella business model, and I think is the basis for the economic success of the IT markets and the wireless communication markets in particular. And I'm going to lay out my headlines up front in case I run out of time. And the first thing I'm going to be talking about is how modern IT markets have relied on a particular way of achieving standardization that differs from the standardization structures that we've seen more commonly in the history of IT markets. In particular, modern IT markets and wireless markets in particular have relied on cooperative multi-firm standardization structures. And from a competition perspective, that's going to outperform and be more attractive than some of the historically more dominant models that have been either top-down models, where the government mandates the standard, or a standard that is mandated as a de facto matter by a single firm. Second, I'm going to show how this didn't just happen, but it relies on a set of legal inputs, secure patent rights, quasi-contractual FRAND licensing principles that are loose and adaptable to changing circumstances in the market, and limited use of antitrust law to mitigate the collusion risk that is inherent to cooperative standard setting. And I'm going to focus my discussion on the role that patent rights have played in enabling these standardization structures to emerge and to thrive. And finally, I'm going to talk about how policy interventions by courts and regulators around the world, in this country, Europe, and Asia, have relied on erroneous empirical understandings of the roles that patents play in IT markets and in standardization in particular. And the result has been that they have placed at risk the legal infrastructure behind an efficient way to achieve standardization without the distortions that are inherent to the government setting the standard or a single firm setting the standard. Right. So first we have to understand what's so great about standardization and interoperability. It's something that we take for granted today, that your Apple iPhone can communicate with your Samsung phone. But that's not something that's always been the case in IT markets. And there's two big economic pluses that we get from standardization. The first is network effects. When my device can communicate with your device, we get network effects. The more users, the more value there is in the product. The second economic plus, which I think is sometimes overlooked, is that when we standardize interfaces and we standardize the pathways for information to travel from one device to another, we also lower potentially dramatically the entry costs into the market, because we enable entry into the market at component levels of the supply chain rather than having to come up with an entire end-to-end solution to enter into the whole supply chain at once. That's beneficial for innovators, it's beneficial for consumers. As we move from 3G and 4G into the 5G environment, we're going to have more information pathways, and standardization is only going to become more important. There's three ways in which standardization historically has been implemented. The first two have in common that those are monopoly solutions to the standardization problem. Either the government sets a standard, for example, the FCC, or a private firm, for example, IBM, back in the post-war period, or MS Windows, even through the present day. What's distinct about current modern IT markets and the wireless communications markets is that most of the standards that we're familiar with, DVD, Blu-ray, USB, and the wireless standards, have all been set by multi-firm cooperative structures. What's so great about this? Well, everything else being equal, if we can achieve standardization without the distortions inherent to a monopoly, and if we can do it through a market-based process rather than through an informationally constrained government process, then the multi-firm cooperative entity would generally be the preferred mechanism for achieving standard selection and standard implementation. I want to dive a little bit more deeply into the mechanics of how cooperative standardization works. There's 4 basic tasks that have to be completed for the process to work. We have to induce profit-seeking firms to invest, to make significant investments in the R&D required to contribute toward a standard over which they will not have sole control. We have to induce those firms to disclose the output of that R&D to firms with which they are in an actual or potential competitive relationship. We then have to agree upon the standard, and in some cases, the principles under which those technologies will be licensed. And lastly, we have to convince implementers to make lower but still substantial investments required to adopt those technologies. Each and every one of these tasks requires secure intellectual property rights. Firms that specialize in innovation are not going to invest in R&D without a property right to extract returns from that investment. They surely are not going to disclose their R&D to actual and potential competitors without embedding that information in a patent right that can allow it to be safely disclosed to competitors. And finally, patents enable vertical licensing that expands access to technology by downstream producers and assemblers. And the result of that is a market structure that looks essentially something like this in simplified form. We essentially have Adam Smith's pin factory, but in a very different technological environment. With the supply chain has been disaggregated, and at every level of the supply chain, the firm that can perform that function most efficiently is the one that's doing it. Why do we know that's the case? Because if that wasn't the case, competitive forces would push these levels of the supply chain to integrate in order to achieve those functions more efficiently. All of these licensing relationships are enabled by patents, and these are patents that are not depriving firms of access. They are expanding and enabling access to a large base of manufacturers. We only have 5 there, but Qualcomm, for example, licenses to over 300 manufacturers. When the market has the 2 key legal and simple legal inputs of property rights and contract, they can create structures such as this. And this is a network graph from my previous research showing what pooling structures look like in the ICT markets circa 2015. When I look at this, I see an efficient allocation of informational assets mediated by property rights and contract. But conventional wisdom sees patent thickets, patent holdup, and royalty stacking, which threaten to increase the price of the smartphone, delay innovation, and constrain output. And this conventional wisdom originating in the academy has appeared in many prominent reports of antitrust regulators in this country and around the world since at least the mid-2000s. There's one problem with this conventional wisdom. Every single empirical study that has tested this thesis has failed to find evidence for it. There is no evidence that high usage of the patent system in wireless markets has harmed that market, and there's only evidence to show that it has promoted and enabled those markets. Output is continuously increasing in the smartphone market. Adjusted for quality, prices are continuously falling. The common claim that royalty rates are in the double digits turns out to be false in most circumstances. They are in the single to mid digits. And we see continuous entry into the handset production market, which makes perfect sense if the royalty burden is not exorbitant, rather it's reasonable. Why else would you enter that market? Based on patent holdup and royalty stacking theories, which have never been shown to be empirically true, policymakers since the mid-2000s have intervened either under the guise of antitrust or patent law in order to limit the ability to enforce patents and in intervening in privately negotiated royalty rates. I'd like to focus on, in particular, interventions that have now made it very difficult for the owners of standard essential patents to have any reasonable expectation of securing an injunction. The absence of an injunction distorts every single licensing negotiation. Without the credible threat to shut down the infringing party. In fact, the infringing party no longer has an incentive to voluntarily pay a license fee, especially a well-resourced infringing party can achieve the same outcome or better simply by waiting it out in litigation. Why should we care about this? The first main reason we should care about it is not so much that innovation will slow down, but that the organization of innovation will be distorted. If the security of a patent right is degraded through legal interventions, all of those transactional exchanges of information that I described to you will now become less secure and riskier. The result is those supply chains will likely reintegrate in order to create closed innovation ecosystems in which informational assets can simply circulate within a firm. That's likely to result in markets that are less concentrated than we see today. The second problem with the current trend, which is moving from a bottom-up, market-driven system of innovation to a top-down system of innovation where governments regularly intervene in order to effectively reset royalty rates through antitrust and patent law. When the market knows that government will do that, we change incentives and we encourage firms to compete in the courts and the agencies rather than in the marketplace. And this is almost explicitly apparent in antitrust interventions, both in this country, but especially in Asia, which clearly results simply in a vertical wealth transfer from firms that are responsible for innovation and pioneering these markets to firms that are implementers in these markets. And the wealth transfer that is going on is not just a wealth transfer between different levels of the supply chain at the firm level. It's also a wealth transfer between economies that specialize in implementation, as in East Asia, and economies that are stronger in innovation, as in this country. That raises a concern that the antitrust and the patent system are being used or will be used not so much to protect implementers against so-called patent holdup, but to expose innovators to patent holdout and to push royalty rates down too low below the efficient level that is required to support rational incentives to invest in innovation. And I'd like to leave you with two little pieces of evidence to suggest this may be occurring. If you go back to the origins of the FRAND requirement in the wireless communications markets, it turns out that that was a compromise between national European monopoly telecom carriers and monopoly equipment suppliers. The European markets were all localized national monopolies. Patents were of no importance to them because they all operated within protected markets. Well, what happened with GSM? Well, we had an outside innovator named Motorola who had a powerful patent position. We had the same concerns about patent holdup that were brought out by the monopoly carriers, and the FRAND requirement was simply a compromise between the carriers who wanted a zero royalty rate and Motorola who quite legitimately asked for a positive royalty rate. That suggests that whenever we see claims of patent holdup, they may be legitimate in certain circumstances, but they may be a narrative that is being used in order to push royalty rates down for the benefit of implementers to the detriment of innovators and potentially to the detriment of consumers. Something similar seems to be happening again in Chinese standardization policy. We know that Chinese antitrust regulators have hit certain US firms or a certain US firm with substantial fines for practices that would almost certainly not be cognizable antitrust offenses in this country. That obviously benefits local device manufacturers in that country. It is also part of a larger standardization policy in China, which is systematically tried to develop indigenous Chinese standards to replace international standards that are subject to patent protection. Again, could be a legitimate case of patent holdup. It looks far closer to an attempt to use antitrust law, or what I would call a use of nominal antitrust law, in order to shift wealth from firms that have specialized in innovation to firms that specialize in implementation and assembly. Thank you.
Good morning. My name is Henry Hadad. I'm Chief IP Counsel of Bristol-Myers Squibb. And I was going to talk to you today about some of the changes I've seen that have either occurred recently or are occurring as we speak in the life sciences, and particularly in the treatment of patients. And what an incredible world we live in today. And while it's a very different set of technologies than what Professor Barnett was speaking about, you're going to hear some common themes. And that is the interconnectedness between the law and the incentivizing, or frankly, sometimes acting as a barrier to further innovation in this space. So I'm going to talk a little bit about some of the disruptive technologies that I've seen, that I've observed over the last few years that are here today, how that has changed the business model, and then ultimately talk a little bit about the law today, and maybe 2 or 3 areas where I think are worth focusing on going forward. So let's talk a little bit about the technology. First off, we've all experienced family members who've had serious disease, and the advent of precision medicine has been a real opportunity for treating patients in a much more focused way. And for those of you who are not familiar with this is the identification of a gene which may be a marker that's highly associated with an advantageous treatment for a patient, and then administering that particular drug. That's been an area of focus in oncology, and it's been one which has been very helpful, not just to patients in terms of treating them with a drug that's actually more focused on their particular disease, but also even in the design of clinical trials, where we can focus on a patient subpopulation that may be more amenable to that treatment. At the same time of precision medicine, the association of a gene with a treatment method, there's been an advent in cheaper and faster and more efficient sequencing of our genes, right? And that's very helpful, going from hundreds of thousands of dollars to literally thousands of dollars, maybe to hundreds of dollars, is now providing opportunity to all patients to make sure they're getting the best treatment possible. So you could argue that precision medicine may be the third leg of oncology treatment. If you talk about early surgery, was maybe the first opportunity. Chemo, which is basically carpet bombing the body and hoping the cancer reacts less well to the drug than your natural cells. And then precision medicine. But now there is a fourth leg. And I'm very excited about that because my company is really on the forefront of that. And that's immuno-oncology. And that's turning on your immune system to treat cancers. And what we're finding is that cancers are very smart, and that they are able to mask themselves, just like our natural cells mask themselves, from being recognized by the immune system, so that they can insulate them from attack by the immune system. So they wear basically a cloak. And if you're able to rip that cloak off, usually by the administration of a therapeutic antibody, you can have your immune system actually attack the cancer. And what we're finding is that it actually is something that transcends different types of tumors and is more reliant on the particular type of mutation that is driving your cancer. So you may have a drug which is helpful for at least a certain population of patients in melanoma, in lung cancer, in head and neck cancer, and non-Hodgkin's. So it really depends on the particular patient's mutations, and also the ability of the drug to access the tumor. So that's a very exciting area. I was particularly excited recently, just within the last 2 weeks, two physicians that I've worked with, both at universities, Dr. Allison and Dr. Hanjo, were awarded the Nobel Prize for these discoveries. So this is really the cutting edge of science, and it's really changing the landscape of medicine. Having said that, there's a long way to go, and there's still a lot of populations which are not successful in these treatments. So we continue to look at different types of markers. It may not be just one gene. It may be a series of genes which really make the body recognize the cancer as different. So these are areas that we continue to do research in, and I think will hopefully bear fruit in the future. There's, of course, related technologies which also change the paradigm of treatment. CAR T, where you actually remove cells from a patient, you engineer them, and then return them back to the patient, which of course raises all sorts of interesting legal issues. CRISPR, which is a platform for many types of gene therapies, but one that now holds the promise of a very precise deletion of certain genes or insertion of genes which could correct a disease. So, of course, another exciting development which could lead to very different types of treatments in the future. It's not just sort of your formal biotech type of work which is leading to innovation here. The use of big data scanning huge groups of data for people's genes to see if there are themes that can be pulled out in terms of disease states versus people's genetic profiles are an important way of doing drug discovery, again, focusing on what would be maybe a more effective treatment. There's also wearable devices. I'm wearing one right now. Today, people with diabetes, people with heart conditions now can use these wearable devices to monitor their health. So these are all very important developments, and I think things that have interesting implications for the legal system as well. In terms of how the business model has changed, drug discovery, development, and manufacture can be very much separated. Quite often, the basic mechanism of action can be discovered at an academic institution or a small company. The development of that drug, which often costs north of $2.5 billion and takes 12 to 15 years and is incredibly risky, is usually done by a bigger company which has the resources and the wherewithal to design these clinical trials. And then the manufacture of these drugs is often outsourced to third-party manufacturers, particularly for smaller companies. Even commercialization, depending on the country, can be. So you get this you can get a very compartmentalized type of approach to drug discovery, development, and commercialization, which leads to very interesting issues around the ownership of IP and making sure that it's effectively transferred between the entities. Business development, again, very different world than we lived in maybe 10, 20 years ago, where you might have licensed in a drug which is in phase 2 or phase 3, relatively late in the process of development. Now people are looking at very early stage drugs because it's so competitive to get exciting new technologies, and that leads to additional risks. And also that an important part of that is making sure you have a strong and predictable patent system which will support that type of investment. Speaking of which, I'd like to talk a little bit about the law and how this is all related. First off, I think we've all experienced changes in other areas, whether it's copyright, whether it's the music publishing area, books, movies, where when it became easier to infringe, there was a basic contraction in the overall pie of what was available in terms of proceeds, right? So a record album went from something that you'd pay what, $12, $13 for, to now buying 99-cent songs individually. And that ease of copying has changed sort of the paradigm for purchasing the product, right? And in terms of what we're looking at, too, with respect to the biopharmaceutical industry, I think you could draw an analogy to the ease of copying, whether it's externally, outside the United States, or internally when the patent system is less able to support and protect these types of innovations. So that's something that we should continue to look at, that efficient infringement is actually the enemy of innovation here, and it's something that we should monitor. And these things sort of take root in sort of, I would say, 2 or 3 particular areas. The changes in 101, patentable subject matter, just at the time when precision medicine and diagnostics are, I think, most important, we're seeing that the patent system does not really support them. And that's something that as a group here, stewards of the IP system who care deeply about it, we should be concerned about because it affects us and it affects future therapies down the road. The IPR system, a system where you spend a significant amount of time prosecuting your patent, examining your patent, and then find out it's at best a coin flip whether 15 years after you've made your investments that patent will be sustained. That is something which is very disruptive to our system of innovation and one that probably needs further refinement. One area that has not been spoken about significantly is written description. That is whether you have properly supported the full breadth of your claim by the information you provided in your patent. And that's an area which I think bears further scrutiny too, because in the biotech field in particular, the ability to get a patent of meaningful scope has been severely limited by a very prescriptive approach to written description, where you're effectively limited to what you've exemplified. And there are certain cases, like a recent case with Amgen v. Regeneron, which I think highlights that unless you continue to make examples, maybe meaningless examples, conventional examples, and put them in your spec, you may not be able to get patents of meaningful scope. So I think that's an area which also would discourage further innovation. And it's not for large companies necessarily like us, but maybe the smaller companies who do the basic pioneering discoveries that often will be the ones that are most injured by this. So those are three areas that I think, thank you, that bear further review. And I'm happy to answer some questions after the rest of the panelists. So thank you.
All right, here's Erika Lietzan.
All right, so for those of you who don't know me, I'm at the University of Missouri, and before I joined the University of Missouri in 2014, I was a partner in the Food and Drug Group at Covington and practiced FDA law. So this is, and my area is sort of FDA and intellectual property intersecting. I'm going to wake everybody up talking about poop this morning. So my focus is on drug innovation that occurs out of order, not in the usual sequence. And let me tell you about medicinal poop, all right? There are communities of microorganisms living in the human body. There is a distinct community that lives in your intestinal tract, all right? We call these communities microbiomes, and microbiota is the actual community. The microbiome is the area where they live. And the community in the gut is called the gut microbiota. Microbiota play an important role in maintaining the healthy functioning of the human body. Among other things, for example, the microbiota in your gut help with digestion of food, they produce vitamins, they stimulate the immune system, and they help prevent the growth of dangerous pathogens. If a microbial community is in dysbiosis, meaning the normally predominant species are underrepresented and the normally contained species are proliferating, you may be suffering from poor health conditions. In the last decade, there has been an explosion of interest in the possibility that transferring microbiota from a healthy person to a sick person might treat or even cure some of these health conditions that are associated with dysbiosis. And of interest right now, for purposes of my presentation, the use of stool from a healthy person to treat recurrent C. difficile infections has emerged as a meaningful therapeutic option, all right? And there is a conventional drug product at the end of my story, not at the beginning. So here's the sequence, all right? The use of stool for therapeutic purposes, including for severe diarrhea, may actually date back thousands of years. The modern era starts with an academic paper in 2010 that described the results of self-administration of stool transfers and explained the procedure. And at that point, it took off, all right? Academic clinicians are the ones that pioneered the treatment, performed the trials, and reported the results in the literature. They're using filtered stool from healthy donors that were known to them or known to the patient, and they're administering the stool typically either by enema or with a nasogastric tube. Publications in 2012 and 2013 reported astonishingly high cure rates, all right? One of them reported 91% cure rate. After that, use of the procedure spread rapidly in the clinics. And at this point, two things happened, all right? First, stool banks emerged. So these are organizations that screen anonymous donors, filter the stool. I love seeing all the wrinkled noses. This is the best part of this presentation. And then freeze it, and then they ship it around the country to clinicians performing the procedure. All right. The second thing is drug companies started developing more conventional presentations, capsules, all right? And these are new, small companies. This is really distracting me. Small companies that are formed specifically to develop these products. And there's basically two ways to do it. You can either, and two approaches that they're using. One is to actually encapsulate filtered stool, all right, that's been stabilized, but it is just encapsulated, naturally derived stool. The other thing that some companies are doing is developing microbial communities synthetically. So they're identifying what are the microbes of interest, and they are designing a microbial community that basically mimics what you would find in a healthy person's stool. All right. FDA has a robust process for new drug approval. So those companies are performing a series of larger and larger clinical trials that culminate in randomized, controlled, double-blinded clinical tests that are designed to provide statistically robust proof of effectiveness. It can take a decade or longer, as Henry said, high hundreds of millions, billions of dollars. All right. Also, some patients, to understand fully the dynamic here, the innovation landscape, some patients are simply doing it at home, all right? Maybe because there's no clinician nearby to perform the procedure, maybe because they are embarrassed to ask a clinician, maybe because they can't afford the fee, maybe because they want to just take care of it themselves because they're not interested in paying a physician for something that they feel like they can do themselves. All right, and there are DIY videos on YouTube. What interests me is the debate that emerged about the regulatory framework that should apply, all right? And it interests me because, in fact, the regulatory analysis is not that complicated, all right? Stool that is shipped, frozen and shipped from one state to another for treatment of a health condition is a new drug, subject to pre-market approval, all right? It may be a biologic, but it's also a drug, so I'm just gonna say new drug. The only alternative to a new drug approval is permission from FDA to do clinical trials in order to get approved. Encapsulated products shipped in interstate commerce for treatment of C. difficile is also a new drug, subject to pre-market approval. Fecal microbiota transferred from one person, I go in with my husband, transferred from one person to another in a doctor's office, doesn't travel in interstate commerce. So pre-market approval isn't needed. If the doctor adds something that did travel in interstate commerce, like saline, then FDA says, well, we have jurisdiction and you need approval. That's a little controversial. But anyway, the point is, this analysis is not complicated, all right? I assure you, it wouldn't be seriously contested by anybody who practices FDA law. All right, we are in a bit of a pickle, though, because FDA has not been enforcing those requirements. It initially decided to let the clinicians and the stool banks basically just operate without going through the FDA process at all, exercising enforcement discretion. It's still exercising enforcement discretion for the doctors doing the in-office stuff, but now it's taking baby steps with the stool banks. They have INDs, which is the permission to do clinical trials, but it's a fiction. They're not doing a clinical trial. Basically, what the agency has done, it has said, send us the paperwork for that, and that gives them a little bit of oversight so they can do some safety protocols. But it is a fiction. It's a fake IND. So that brings me to the regulatory debate. There's been a series of legal and scientific articles that have argued that the new drug approval paradigm is not appropriate. Physicians should be left alone entirely, but more importantly, for what I want to talk about, the stool banks, they say, should be permitted to operate indefinitely, permanently, without pre-market approval, in direct competition with any encapsulated products that come onto the market. They're making some scientific and regulatory arguments, but those are all softballs. They're easy responses to these. The key arguments are not grounded in science. They're not grounded in the regulatory framework. They're actually focused on the economic implications of the new drug approval paradigm applying. The problem that they see is that regulation as a new drug means that the first commercial sponsor is going to have data exclusivity, all right? And they're explicit about this. Let me explain. I know there's a lot of tech people rather than life sciences people here. The companies that are developing these capsules are generating a large amount of data, right? Safety data, efficacy data. The way our drug approval system works, once the capsule gets approved, those companies have exclusive rights to those data for a period of time. After that period ends, other companies can come in, they can get copies approved without generating clinical data of their own. But until then, that pioneering company has data exclusivity, and at least in theory, an opportunity to recoup those hundreds of millions or billions of dollars that is spent generating the data. The concern seems to be that if FDA approves an encapsulated product, that product is going to have data exclusivity and therefore be expensive, out of reach for some patients, and if FDA doesn't continue to leave clinicians and stool banks alone, those patients aren't going to have treatment options other than DIY, which people pretty much treat as not a safe option. But what happens if FDA agrees with these people, all right? What if it continues to basically ignore the law as written? Because remember, I'm telling you, the FDA framework, it's not contestable, really. It's not complicated. If they ignore that and they let the stool banks continue to ship frozen stool without approval, while encapsulated stool has gotten approval, if it permits that to continue with them in direct competition, what happens? Maybe insurers will cover and patients and physicians will prefer the encapsulated stool. All right, maybe because they're squeamish. Or there's 10 years of research showing the encapsulated product is effective to treat C. difficile. Or maybe insurers and physicians and patients are going to say, thank you very much to the companies that studied the naturally the filtered stool capsules and continue to purchase from the stool banks. And if that's what happens, all right, it's very hard for me at least to imagine that other uses of human microbiota that emerge from academic medical centers, and they are emerging, it's hard for me to imagine that as those emerge, other firms are going to consider doing the kind of research that FDA, at least for its part, thinks is proof of an intervention's effectiveness, all right? And this dilemma, I do this when I teach as well. I have a great slide that I skipped. This dilemma is not unique to fecal microbiota. So what I'm talking about is the challenge of encouraging the kind of research that, let's call it FDA gold standard research, the kind of research that proves a product is effective, encouraging that after the product, the therapy has become widely and inexpensively available in the marketplace. Normally, FDA is the gatekeeper, and the research is needed in order to get over the barrier to market entry. This is out of order, all right? And FDA faces this same challenge in a variety of other contexts as well. I'll just talk about the top one in red for a second. There are thousands of prescription drugs on the market today unlawfully, all right? They're, quote, new drugs, so they need approval, but they have been marketed. Some go back to the beginning of the 20th century. Some actually go back to the 19th century. Historical reasons it never happened. They don't have approval, all right? FDA can't force these companies to file applications because it doesn't have the resources to actually pursue enforcement action, and that would take cheap medicines away from patients. But if someone actually does the research and generates this robust proof of efficacy, gets an application approved, they'll have the data exclusivity because that operates by law, and at that point, FDA does remove the illegal products from the market, and that takes cheap drugs away from patients as well, so of course everyone is quite upset. It's the same basic pattern. These examples all vary in their specifics, but what they have in common is that we value a certain type of testing, or at least we think we do, and the treatment or the substance is somehow already available, all right? I think that these scenarios, these out-of-order scenarios, are helpful analytically because they allow us to see pre-market testing alone as a distinct kind of innovative behavior that we need to encourage. And there's an intuition in patent law, all right, that exclusive rights are not appropriate in something the public has already enjoyed the benefit of, although patent lawyers will understand here what I mean. We don't take things away from the public, all right? And some invoke that argument here. They say exclusivity is meant to encourage firms to carry new products through the new drug approval process. It's a bargain with firms, and it breaks down, the bargain breaks down when the drug is widely available already. The question is, what's wrong with that intuition here? And I would say it misunderstands the innovative behavior that data exclusivity is meant to encourage. These scenarios, I think, show that there is a difference between the thing and the information. We have the thing, but we still need a specific type of research done, or at least we think we do. How do we provide an incentive to generate information alone? I think these scenarios will help us refine our thinking about data exclusivity. All right, and I think that there is going to be more of this. All right, more interventions that emerge this way. There's a lot of research going on with respect to other microbiomes and possible therapeutic use. There's cell-based therapies as well for orthopedic injuries coming out of academic medical centers. So the first question is, I think, do we want this FDA gold standard research eventually done for these things, all right? I think that we have to ask, whether fewer data or a different type of data would be appropriate. Of course, medicine should be safe and effective, benefits should outweigh the risks, and so forth. It is hard for me personally to imagine that we would accept a lesser degree of confidence in the efficacy of some medical treatments and not others. Stool in capsules versus frozen stool in baggies. I don't know that they're in baggies, frozen stool. It seems to me that we ought to be equally confident regardless of the form. But I think we have to. I'm out of time. I'm going to take another minute or two because Henry went under, so I'm going to use the last 2 minutes of Henry's time. We need to examine our assumptions about the quantum and the type of evidence that we desire for medical innovations. But if we do want the FDA gold standard level of confidence, I don't think there's any way to avoid the fact that it's expensive, all right? And I think this FDA is going to have to do what it can to ensure that the exclusivity is meaningful. So it does, I think, have to seize enforcement discretion with respect to the unapproved and therefore illegally marketed products, competitors, when a company actually completes the process. I think some might say, well, the market can sort this out, right? If the new approved treatment is, in fact, superior to the unapproved alternatives, people will buy it. But remember that the unapproved alternatives are being marketed illegally, all right? And most importantly, the primary policy objective here is just research, all right? It is not the development of a product that is differentiatable in the market. 2 final points here. I do think this market reaction, the public reaction, if you will, we have to pay attention to it, all right? If there is an outcry about the second generation of patients having to pay more than earlier patients did, I think we have to ask whether this means we value this gold standard as much as we think we did, all right? I think that's a reasonable question to ask. If we do value it, though, this is still the classic innovation access payoff, a trade-off that all intellectual property presents. It's just that the out-of-order sequence is making it hard for people to swallow, all right? And I think ultimately what we have is a problem with discourse around innovation, all right? So one of the solutions, if you will, in this space is that more work has to be done by all of us, by people like me, connecting exclusivity, data exclusivity with research, all right, in the public discourse. And then the last thing that I would say is that FDA has to avoid getting itself into situations where it has used enforcement discretion for so long that ensuring meaningful exclusivity for people who actually file marketing applications becomes politically impossible. That is a risk with the microbiota for C. difficile. And it counsels, I think, against a repeat of the stool bank scenario, enforcement discretion, go out and ship, as other uses of microbiota emerge out of academic clinical research and other similar types of therapies emerge out of the academic clinical setting, and they are emerging now. And that's it. Thanks.
All right, now we have Jake.
Good morning. I think only a handful of you here know me, but I've been with CPIP since practically the beginning. I think I was their second student researcher. And if you came to the first annual conference, I may have been one of the people handing you your name tag at the time. So it's sort of come full circle for me now, and now I'm sort of honored to be here and talking in front of so many esteemed professionals and academics in this field. I'm definitely the most junior panelist today, but I think I bring an important perspective here from the front lines of patent enforcement. So I work for Dominion Harbor. We're a licensing firm, patent monetization firm, NPE, PAE, and as you heard yesterday, privateer. So, I'm sort of in the trenches every day, actually seeing what the value of patents are from the perspective of licensing. And I get to see what the state of the law is and how that affects the actual value of patents. So there's really 2 things I wanted to discuss today, and they're really both related to something that Henry sort of touched on already, and it's this shaky foundation that sort of patent law is standing on today. And what I mean is patent eligibility, whether a claim is directed to patentable subject matter, 101. So, and as the Federal Circuit has said, right, although there's a presumption of validity, there's no equivalent presumption for eligibility. So there's this lack of presumption that has allowed district courts to sort of decide whether a patent's eligible or not on an ad hoc basis, and it's created a lot of unpredictability. And this unpredictability is eroding patent value. That's the first point. And the second point is, as patent values are eroding, then it really only serves to stifle innovation. Because after all, what's the point of innovating if you can't protect that innovation and reap the benefits? So, you know, the title of this particular panel is new and shifting business models for innovative industries. But, you know, ultimately from my perspective, the core business model of innovation of these industries is largely unchanged, right? Pharma companies are still going to develop, you know, new drugs. They're going to have better targeted gene therapy. Chip manufacturers are going to make smaller, faster, more efficient chips. But what about their strategies for innovation itself? Are they patenting more? Are they patenting less? Or maybe they're changing their focus on what they're patenting and what they're innovating. Well, whatever their decisions are, they are really going to be based on the value of the patents that they're able to get. And so, as I mentioned before, I see the value of these patents declining, and I want to explain why that's a problem, where that comes from, and maybe a solution for that. So let me just start with sort of the litigation landscape here. This is just a figure that's pulled from a Docket Navigator report. They publish an annual report every year. This one happens to be for patents. This is from their data from 2017. They mine data from Pacer and other docket services. And so what we've got here is just new litigations filed by district courts in the blue line, and we have new PTAB decisions, new PTAB filings in the green line, and then there's an ITC line that I'm not really going to talk about here. But I've also labeled where the AIA was enacted, and which introduced IPRs, of course, and that's where you see these PTAB proceedings start coming from these IPRs. And I've also labeled where Alice came down, and that's really what sort of opened the floodgates for challenging patents under 101. And so really I want to point out is, before these events, we were seeing an almost exponential increase in patent litigations before these two. And now it's a steady decline. And in fact, the cases filed last year are about 25% less than they were before the Alice decision. So why is this? Why aren't there more patent litigations than ever? And I really think it boils down to two major reasons. The first being, well, the PTAB is invalidating patents left and right. So when you invalidate a patent, you can't file new cases. So we've got that issue. And then there's another piece. There's this fear of invalidation, and not just by the PTAB, but by the district courts as well. So patentees will file fewer initial cases to sort of test the waters as far as 101 and 102 and validity is concerned here. So what do I mean by this? Well, let's take a look at a quick comparison of two claims from antivirus patents. So I don't expect you to read through all of these, but just get the general idea here that the left one is really about creating a security profile for a potential threat, which they call a downloadable, and then linking that security profile to the downloadable before allowing any clients to access that file. And then on the right, we have a claim that's identifying a threat on one system based on identifiers generated and downloaded from one or more other systems out there. So the question from a patentee's perspective is, are these valid in the eyes of the court? What's going to happen? Am I going to survive in the court? Well, both of these have been decided in the court already. And you may be thinking, well, without digging too deep into the patents, well, the one on the right seems to be a bit longer. It's got more limitations. Maybe that's the one that's going to survive. But it's actually the opposite in this particular case. So on the left, we've got a claim. They're both 6 series patents. They're both method claims. The Northern District of California, surprisingly, said that the one on the left was eligible, while the Federal Circuit affirmed the Delaware District Court's finding of the one on the right being ineligible. And really, the point I'm trying to make here is that it's extremely difficult to decide beforehand which patent is going to survive. I mean, you have both of these patents have like hardware components. They have seemingly non-generic components. We've got something over here called an inspector. We've got another piece over here that's called a content identifier generating agent. So they're not necessarily just generic components, but it's extremely difficult to tell before you start whether your patent's going to survive an eligibility challenge in the court. And you can sort of justify it now, knowing with hindsight, saying, well, now I see why the court said this or whatever. But beforehand, it's really just sort of a toss-up. And the infringers are well aware that there's this problem with eligibility, and they take advantage of it. I want you to take a look at just how prevalent 12b6 motions to dismiss have become based on 101. And so this just shows the total numbers of these motions to dismiss based on 101. And again, I've labeled where the Alice decision came down, right? So before Alice, there were 7 motions an entire year. And now we have, last year alone was 88. That's a 10-fold increase. That alone should show you that there's a problem here with eligibility. Let me break it down a little bit even further. So if we take a look at what individual courts are doing, with the exception of the Eastern District of Texas, there's pretty much a greater than 50% chance that a patent is going to be deemed ineligible in any of these courts. So what does that mean? From the defense's point of view, there's really no downside to filing a 101 motion, right? If you've got a risk-averse patentee, they'll want to avoid any sort of invalidation, and so what they'll do is devalue their patent by incorporating this risk of ineligibility into their asking price for a license, so defense can get a cheaper deal for their client. Even if the patentee is willing to roll the dice and say, you know what, I think we're going to win, the defense knows they still got a better than a 50% chance that they're going to win, and that patent's going to be invalidated under 101. Even if the defendants lose, they still can get a second bite of the apple, right, at the motion for summary judgment. So there's lots of chances for the defense to sort of shut down these cases and devalue the patents through this uncertainty in eligibility. In fact, I hear it's pretty common now for firms to even offer filing 101 motions for free. They only make their client pay if they lose. And when is that really going to happen, right? If they file these 101 motions, then they're going to get a cheap deal for their client, right? And if that goes through, then they didn't technically lose, so they get the charge for that. So essentially, 101 has become a quick way to devalue a patent solely because eligibility is unpredictable. Now, there's some ways now to combat this. Thanks to Berkheimer, right? You can, at the pleading stage, incorporate more allegations that the invention is not a well-understood or routine and conventional application of an abstract idea. You can do that when you're drafting the specification. But let's face it, these are ultimately just ways to create delay, right? There's still going to be a decision that comes down, and it's not really a solution to the uncertainty surrounding eligibility of a patent. So 101 uncertainty is a huge issue. It's causing this decline in patent values. But what does that mean for innovation as well? Well, let's take a look at Uber as a quick case study. So Uber's published an article in IM Magazine, and it's published online. And they discuss how they decide whether to patent something or pursue an innovation. And so they've used data analytics to do this. And so they've got 2 equations here, and I'm no mathematician, but I can at least parse out the variables that are involved, right? And so we've got an impact score at the top, and really this is just portfolio score. How strong is a portfolio for a particular feature? And things that they factor in there are the coverage, royalty rate, how big the revenue stream is going to be, and then there's another piece there that is how significant is that feature? And I'll get back to that in a minute. And then they also have another equation here for this probabilistic coverage of the likelihood that a patent reads on a particular feature. And really, this is more of a measure of essentially the strength of a particular patent in that portfolio. And again, some of the key things here are how many patents do you have that cover that feature, and how likely are they going to fail in enforcement. So really, from Uber's perspective, there's 2 ways to increase the strength of their portfolio, right? They can avoid patents that are likely to fail in enforcement. So we're not even going to try getting patents where we think there's 101 susceptibility. Or they can focus on innovations that have an increased significance, so more important innovations. But that comes at a cost, right? So if you're focusing on more important innovations and you have a finite amount of resources, you have to neglect things that are just marginal improvements. So there are a couple good quotes from that article, and I just wanted to read two real quick. So Uber says that when a product's covered, additional patents in that area can be abandoned, divested, or ignored because owning such assets is not financially justified. So they say, look, if we've got a core set of patents that we think covers some of the main features, we don't really care, we don't have to care so much about maybe minor improvements that are related to it, so we're going to ignore those innovations. They also said that patents that only map to features with more speculative significance may be deprioritized to invest in areas with higher marginal value. So again, showing that we're going to focus on patents that we think have a bigger impact, that are going to be more of a game-changing innovation. So what does this mean for the amount of innovation that's actually happening? Well, let's face it, they were never going to ignore game-changing innovations in the first place, right? So they may focus more on that, but that doesn't necessarily mean more innovation. It's the same amount of innovation because they were going to pursue it anyway. But really, it's about the cost of ignoring these marginal innovations, right? They're not going to proceed with pursuing maybe small improvements that, who knows, could have ended up being very valuable. We'll never know that because they're not focusing their attention that way. So what we see there is that there's a net loss in innovation because of these ignored marginal patents. So while I'm speculating a little about what's happening in the innovation industries, because I'm not directly involved in them myself, I can tell you a little bit about what I've personally been seeing. I see one-on-one promotions pretty much guaranteed in every case where there's even a slightest hint of susceptibility. And the patent values are reflected in the licenses that come out of these. These patent values are decreasing because of this risk. There's a general aversion to patents that appear to have any sort of one-on-one susceptibility because we know they're worth less. We know we're not going to be able to get the most out of them because they're susceptible to this uncertainty and eligibility. And ultimately, because there's no really clear guidance about what is eligible and what isn't, it comes down to a gut feeling from somebody evaluating the patent to say, oh, I think this is going to be eligible or ineligible. And really all they have to draw from are anecdotal evidence from the various district court rulings that have come down in maybe similar fields or similar patents. But again, you still don't really know what's going to happen, except there's greater than a 50% chance that it's going to be invalidated if you're outside the Eastern District of Texas. So what do we need? What we need is some clear guidance about what is eligible and what isn't, and in order to restore this sort of lost patent value that's resulted from this uncertainty and eligibility. That's it. Thanks.
So I think we're going to open it up to questions now, and there's a couple microphones. I think people are going to be moving around with microphones. We have a questioner right there. Maybe we can get him a microphone.
Thank you. I had a question that came up listening to Professor Lands. I'm an IEEE member, and I'm in private practice. And I've represented startups in the telco, virtual reality, in the one-on-one area. And I've got a couple partners that have PhDs in biochemistry, and I don't really understand the life sciences area, but I know that recently I found myself dissuading startups from pursuing certain efforts that are now under a cloud because of things I'd mentioned yesterday. The smallest saleable component creates an erosion, and when somebody moves the cheese, the mice just don't show up. So a thought came to my mind as I was watching the professor's presentation. What's the difference in life sciences fields over, say, telecommunications, that you don't have patent pooling arrangements and you don't have standards constraints? If you or Henry could answer that question. Thank you.
I think you should answer that question, actually.
Well, I can talk a bit about the life sciences. So I think we're going to start seeing standardization becoming more and more an issue. And let me explain why. Historically, we've had models where, for example, because of the Hatch-Waxman system, you create an innovation, you invest huge amounts of money in its development, and ultimately that data doesn't have to be reproduced by a third party. That third party can just copy it after a certain point. That's what data exclusivity is. And then if there's patents, there's patent challenges, and then the system works to allow access to cheaper medicine at a certain point, and also pushes the innovator to go to the next level and make the next thing. But generally, it's been relatively distinct innovations not a convergence into sort of one area. What we're seeing more in biologics, frankly, is because of, I would say, a weakness in the patent system, you're seeing multiple innovative companies targeting the same target. So it could be in the TNF space for autoimmune disease. You have 5 or 6 innovative companies, now some biosimilars, all in the same space. In the immuno-oncology space, again, now 5, I think, companies now effectively targeting the same PD-1 receptor. And they're also all doing research as to what is the appropriate dosing and what level of maybe a marker on a cell or in a genetic profile is the thing that would be the best way to treat a patient. And what we're seeing, I believe, is a convergence there where we're all going to be cross-licensing each other in this space, because it does us no good if one party has one diagnostic and another party has another diagnostic. It makes the most sense where there is a universal diagnostic and the parties can then compete based on the nature of their product and the robustness of their clinical program. So I do think that'll be happening, but I think the model was different, and maybe that's why we didn't see it historically. Maybe on the tech side, people have a different point of view.
Anything, Erika, on that?
No, I don't have anything to add.
Yeah. What about like gene editing? So you talked a little bit about gene editing. Is that the type of movement where you could see some kind of standardization, that they'd want to have some kind of standard platform for that, where maybe some kind of patent pooling would make sense?
So that's an interesting question. I think it's for those of us who practice in the life sciences, we're probably very familiar that there were a couple of competing parties who have sort of been the innovators around CRISPR, for example. We have UCal on one hand, and then you have the Broad Institute, and there's been a huge dispute across the United States and Europe and elsewhere. I think these are one of these things, like in many areas, where ultimately things shake out. There's probably some cross-licensing going on, and in the end, certainly more than enough to go around in terms of licensing revenue to justify that type of investment initially.
Right. Yeah, I know there was, for like ag biotech, how you would transform a plant. There was a lot of work on patent pooling by a group in Australia, and there was a lot of energy went into this, and it never went anywhere. So I'm not sure exactly why, but it seems like even though it seemed like a good idea to certain academics that we needed patent pooling in biotech and with gene patents and so forth, it never really seemed to come about.
I think more natural cross-licensing is what's happening.
Yeah. Are there any more people with questions or comments? Or there's somebody right there.
Yeah,
Oh, he's
question to Jake. You're talking about software patents when you're talking about the 101 problem?
Mainly software, but it also applies to the biotech field as well if we're talking about methods of treatment. But typically, it's method claims that some sort of operating system, but definitely software.
So we're talking about 90%, around 90% being software?
Quite a bit, yes.
So the problem is the PTO is issuing poor patents, right?
Yeah, it's not clear, right? It's really about what guidance do they have? How do we know if something's eligible or not? I don't know if it's the PTO's fault or maybe the courts are confused about what's eligible or not. It's one or the other, though.
Okay. One more question. Question for Henry. How is SAR used in your shop as far as developing products? Do you include SAR in the description, in the specification? How do you use SAR?
Maybe could you just explain to the audience SAR?
SAR is structure-activity relationship. It's a way of basically building a pharmaceutical without actually having to do the clinical trials and things like that. You look at various characteristics of various groups on a chemical, on a drug, and if you want to change its characteristics, you want to make it more lipid soluble, you add a group chemical group that'll make it more lipid soluble, and it'll stay in the adipose tissue longer. It changes the delivery, the way it's dispersed throughout the body. I do a lot of SAR. I've done it in the past, and I don't know how it's used these days?
I think in most chemistry, I won't be speaking specifically to Bristol-Myers Squibb, but I think most departments, particularly chemistry, discovery departments, do use SAR as one of many tools to design a molecule. And but it's just one of many. And it certainly doesn't really necessarily help in terms of designing clinical programs. It helps you get that initial molecule. It helps you determine whether there's high activity and potentially lower toxicity in vitro. But then ultimately, when you do the preclinical work in animals and then the clinical work in people, you really get a sense of whether the molecule will be successful or not.
Do you use a lot of SAR lingo in the specifications of your patent applications?
I don't believe so. I don't think it's really something that is necessary to support a specification, so long as you describe the chemistry and describe at least certain data around it.
Okay,
So thank you.
thank you.
All right, is there anybody else? Does anyone else have a microphone yet? Or, well, there's a question right here, and then there's one back there, so we got two people right now. There's another person who had their hand raised over there.
This is a question for Mr. Hadad. You described the compartmentalization of sort of the drug development and distribution process. And with respect to the manufacturing component, I'm wondering if any manufacturing of patented drugs takes place in China, and if it does, if there are particular IP problems that present themselves and how companies guard against them.
Yeah, that's a great question. Again, I'll speak just generally about the industry. I mean, there is, as I mentioned earlier, particularly for smaller to mid-sized companies, a need to outsource manufacturing to bigger companies which have the scale to do the type of work that needs to be done. While there is some manufacture in China, I think you're seeing, particularly in the biologic space, more of a concentration, for example, in South Korea with companies like Samsung, who do both contract manufacturing for innovators as well as biosimilars. So it leads to interesting questions, for example, to make sure when you enter into a contract with a company like that, that the work and know-how that you're giving them to manufacture your drug will not ultimately be then transferred for the manufacture of a competitor down the road. Speaking specifically about China, it is a weaker IP system in terms of enforcement. It is one, though, that has seen dramatic improvements, and we're hopeful that in the long run, that China, because they are very interested in developing their own innovative biopharmaceutical industry, will have a robust enough IP system that we can at least protect some basic things. But having said that, there's still a fair amount of risk now that you'd be able to protect, for example, your trade secrets or ultimately enforce your IP there.
All right. We've got Josh back there, and then I know somebody else had a hand up over there. Yeah.
Question for Professor Lietzan. Comment then a question.
Can you speak up just a little bit?
Yeah, sure. The comment is, if you really care about developing the information, why not just change Heckler versus Cheney and allow people to sue the agency to force them to enforce, or similarly just directly enforce the FDA's regulatory approval requirements? The question is, why hasn't the liability system taken care of this already? Because if there's no enforcement going on, it's not an approved drug. There can't be a preemption of liability in that case. So that should be an incentive for the people on the market to actually get the approvals to get the preemption.
Right. So why isn't the liability system? I think part of it is you're talking about different players. So you've got the stool banks have kind of a well, let me say a couple things. First of all, they very much have a white hat kind of persona in the marketplace that's part of what's going on. But we're talking about different players, right? Why aren't they incentivized by the liability system themselves to generate the data that FDA would view as sufficient for pre-market approval? I mean, part of it is they don't have the capability of making the product and doing those trials. I mean, it really ends up having to be somebody else, a different kind of outfit. They are doing the safety stuff already that I think FDA would care about with respect to things like infectious diseases and so forth, the filtering. And they are relying, I think, in large part on the efficacy results that are coming out of the trials that the academic medical centers are performing. So I think the question really points to one of the things I asked, which is whether we want the other research done, right? I mean, I have always thought that the liability system itself was not sufficient. The kind of research that companies end up doing, the full-blown pre-market R&D process that companies now have to do, is a lot more than would be necessary to satisfy a company's business judgment that they weren't facing products liability. And this actually may be a way of showing that, because these stool banks are willing to operate without having done that research.
All right. Any comment, Henry? Yeah, we've got another question now, yeah.
Yes, so Mr. Hadad and Mr. Mace, you both talked about eligibility as at minimum being uncertain and maybe at maximum actually, if 50% of the districts are, 50% of the motions to dismiss are being granted in all districts except Eastern District of Texas. That is lowering innovation. But do you have more specific examples of things not funded, research that was abandoned, et cetera, et cetera? That level of impact on innovation for the American economy.
So unfortunately, I don't have insight into the research processes of these companies, but I can tell you that when we have patents that come across our desk, right, from inventors or operating companies that seek to monetize them, and if they're loaded with these 101 issues, they're passes. So what would be the incentive of pursuing more of that research if they know they can't monetize it?
So perhaps I'll, without getting into specifics, I think we can look no farther than Erika's presentation to say, okay, what type of patent protection can you give a specific ratio of naturally occurring microbiome, cells, the bacteria in your gut when you administer that? And the question, at least at this point, is very uncertain, right? Whether you could get any meaningful patent protection around a pill which contains the appropriate flora that would give you a very effective treatment potentially. But yet you're still going to have to develop this and spend quite a bit of money to develop it and make sure it gets FDA approval and approval around the world. So there's an example of something where it is somewhat speculative as to whether you would be able to get meaningful IP protection because of the changes to 101. The other part of 101, and I think some of us have recognized this, it's a bit of a black hole with this expanding event horizon. And, yes, there's been some helpful case law recently, like in Vanda, but still, things like methods of treatment. When you're talking about a method of treating a disease with a drug, literally everything is arising from some type of natural phenomena. And there's always some type of argument someone is going to make, and they do, that your method of treating is unpatentable because it's ineligible subject matter. And it, at least in my experience, at least gets enough play that it makes it past the initial gatekeeping mechanisms, and then you potentially have a live issue. So I think it's something that we really do need to cabin. I think the USPTO director is making a important effort to bring some practical approaches to examining patent applications under 101, both in terms of some of the memos that have been recently released and also his recent speech at the IPO annual meeting. I think the courts are struggling, frankly, and that uncertainty at the very least is creating uncertainty, not necessarily just for big companies like ours, but the smaller companies who really rely on some of those pioneering breakthrough inventions and, frankly, the patents as a hedge from somebody just taking it from them. That's where I think we're going to see the greatest drag on innovation in the long run. That helps, Mark.
All right, we've got Bob.
Let me actually address that. You're asking the question as to what is the evidence that innovation is being affected. You're sort of asking about the dog that doesn't bark, right? You're asking about just what evidence that decisions are being made. But what is the visibility of that? It's going to be very hard evidence to get. That said, in kind of a related way, I came up with a data set, and Kevin and Adam published an article that, based on that we looked at identified instances where there had been U.S. patents that had been denied under Section 101. This is related to various cancer-related therapies and other life sciences, and yet had issued in other countries as kind of an indicative that research being done here or for products that were going to come to us wasn't being granted, and that yet that same type of innovation was being patented elsewhere, which would suggest, again, not direct evidence, but would at least suggest that those types of resources are being allocated elsewhere. So it's kind of hard to get direct evidence of things that don't happen. You can kind of get it indirectly. I mean, there's lots of anecdotal evidence we hear from practitioners that they're recommending their clients don't file. Okay, so if they're not filing, there's kind of a backup of well, are they actually going to be putting resources into those? But it is a hard problem, but it is certainly an important one to try to find some way of systematically getting evidence. I think one thing over time we may be able to look at is declines in filing rates in various art units in various technology centers. Again, you have to kind of infer backwards. They may still be inventing in those areas, they're just not filing. Hard to tell, but it's a very important question.
All right. We have another question over here, and then we have a question in the middle.
I have a follow-up comment to what he just said. It's not that they don't file. I've had a couple friends come to me, and they've serially done a few startups, and they're in the one-on-one area. I sit down and lay down the risk. It's not that they don't file, they don't do it. In fact, I advised a client to the extent that he could play a piano or a guitar, he should start writing sheet music, and it might be productive, and his great-great-grandkids might live in the lap of luxury if he's good at it. But if he keeps doing what he's doing, he's wasting his time.
All right, we've got a question here.
Yeah, Rob Atkinson, IT. So I had a question for Jonathan. You had these three models of how you do this: government, monopoly, and industry. Obviously, the third is the best. And the Chinese have been in category number 1, but they're sort of moving to category number 3. But some argue that they're sort of using government to influence category number 3, that process, in an unfair way, sort of flooding the zone, manipulating. So it looks like it's privately led standard setting, but it's really sort of government led or influenced. Do you agree with that? And if so, do you think that's a problem?
Yeah, I agree with that. Those are idealized structures. In the real world, you see hybrids between the two. You often see hybrids between government standard setting and then working with a national monopoly, something you saw in the European telecom markets, especially AT&T in this country could qualify as that. I think what is worrisome in any country, it happens to be China right now, that's doing that, it's essentially a government-supported monopsony. And so the problem is that it's liable to push the pricing of the IP asset away from the efficient pricing. Right? So as everyone's well aware, in antitrust law, the objective is not to get price as low as possible. It's to get price to the efficient price. And especially when we're in the innovation context, we need to deliver a premium over to the innovator to compensate them for the costs and risks that have been incurred. And one thing I would just add, that slide I showed in the standardization timeline where you develop the standard and then you implement the standard, virtually all of the policy commentary about patent holdup and so forth has been looking at the risk posed to the patent and the costs incurred by the implementer. All of that discussion kind of assumes that the R&D is just there. In fact, far more costs are incurred by the innovator and far higher risk because those costs are incurred well before there's any information or certainty that the standard will be adopted, or if it's adopted, that the technology they contribute will be into the standard. And so the simple answer is yes. I think it's essentially it's a government-supported buyer monopsony, and it threatens to distort the pricing of IP assets globally.
I've got a follow-up on that. So you talked, the Chinese are attempting to develop endogenous technologies for it. Is the idea that there would be two standards in the world, or that they would dominate. There'd be one standard, but they'd be the Chinese technology.
Yeah, the literature, in this area, the answer is that the objective appears to be both of those. The first is to establish a domestic standard that is not dependent on foreign patents, which is consistent with the strategy of pushing down the input costs and increasing the margin of the Chinese manufacturers. And the second is to establish, to seed that standard in overseas markets and establish it as a rival international standard. And that, again, operates to the advantage of the midstream and the downstream manufacturers that are their local constituency. None of these efforts so far have been successful, either because they've been unable to develop a technologically comparable standard, and so even the local device manufacturers have resisted adoption of the standard, or they've ended up being reliant in any case on foreign technology, and so they haven't achieved their objective of pushing down the input costs unless the government intervenes to reset the royalty through again what I would call nominal antitrust law.
All right.
I have a question for any or perhaps all of the panelists. Is the solution to the patent problem that you've identified this morning a legislative solution? Is that the best answer, or judicial solution? Will the courts eventually get it right?
Almost like it has to be legislation, because the courts are trying, but they're all over the place. And I think Congress needs to step in at this point and give some more guidelines about, at least from my perspective, what's eligible, what isn't, that the courts can then base their decisions on, because right now it seems to be quite a bit of a mess.
I would just add to that, I'm not sure which venue could also be regulatory. We see some important movements since last November from the antitrust DOJ in a policy shift. We see a policy shift emerging at the PTO. Wherever it happens, I think patent policy in the standard essential patent area, which again, I'm sure everyone appreciates, is a market representing billions of dollars in value, requires a reset to appreciate the interests of the innovator, the historical strengths of this country in innovation, and to correct the skew in policy which has disproportionately favored the interests of implementers. It's politically popular because it seems to translate into reduced prices for consumers. I'm not sure that's even true, but even if it is true, it's a short-sighted trade-off that trades off minor price reductions, if any, in the short term, for a long-term loss in innovative vigor in this country.
Yes, so I think each of the different issues identified may have a bit of a different answer, too. I think when it comes to the patentable subject matter 101 discussion, which has been most of the focus of today, the Supreme Court has sort of indicated, at least for now, not wanting to take this up again. They had some vehicles which could have been nice ones to re-examine the way they approached it earlier, and they chose not to. So more likely than not, absent some type of legislative change, I think we're going to be dealing with a lot of uncertainty going forward, despite efforts by the courts and the USPTO. Turning to the IPR piece, the inter-parties review, which wasn't dealt with as much, but I think, quite frankly, on a more fundamental level, is really a more troubling development in terms of the uncertainty of the right or the weakening of the right. You have a statute which permits a huge amount of discretion by the USPTO in terms of creating rules, which could make it less likely that your IP, after making a huge investment, 10, 15 years, is going to be thrown into a system where it's at best a coin flip, at worst maybe a lot more likely than not that your patent is going to go down. So that's the good news, is that the PTO can do things by rule. I think the bad news on that front, though, is that if that can be done by rule, then this could change every 4 years or 2 years or 3 years. And it's really no way to have a property right. Frankly, if I bought a plot of land and someone said you can build a house on it, but it may be taken away from you, and it may depend on who's in office any given time, I don't think you're going to do it either way. So I think that's a system where there may be sort of a partial fix by regulation, and there may be a longer-term fix by statute.
All right. Any more hands? We've got a few more minutes. Maybe, does anybody on the panel have any questions or comments based on other people's? Or we do have a hand, I guess, yeah.
As to a legislative or a legislative fix versus will the courts get it right? In the first instance, there's no question we are talking technology policy. Okay, what is patent eligible subject matter is a policy question. There is no, on that, it is Congress's purview. It is not the court's purview to decide what the technology policy of the country should be. So whether the court will get it right is in some sense a red herring. It's not their business to get it right. It's Congress's business to get it right. In fact, in Bilski, they even say, it's important to emphasize the court today is not commenting on the patentability of any particular invention, so on and so forth. They say, nothing in this opinion should be read to take a position on where the balance ought to be struck. So the court itself has recognized it's not their job to set the technology policy. It's Congress's job, and yet that's where we really seem to have been defaulted, that everyone's kind of letting the court do it, and no one is backing up and saying it's, recognizing that this is a policy question. It is not a legal, intellectual discussion of what is the scope of eligible subject matter, as if it was, angels on the head of a pin. It's policy.
All right, well, we've got just a couple minutes. I guess maybe one more question. Yeah, Adam.
So this is a question for Erika. Although I would also like to say we're going to be officially changing your title to Senior Scholar of Poo at CPIP. Yeah. I wanted to push back from kind of a broader kind of non-IP con law level about your claim that self-treatment or treatment in a doctor's office just between two people wouldn't raise interstate commerce issues and therefore implicate.
It's not a constitutional point. The statute is different from the Constitution. It's much narrower.
The statute actually
The FDCA requires shipment of a thing in interstate commerce. It's much more narrow than the Commerce Clause jurisprudence would have allowed Congress to write.
And was that a deliberate policy choice by Congress?
No, it dates to 1938. And one of my poor, unfortunate research assistants spent about a month going through the legislative history, looking at discussions of the Commerce Clause jurisprudence throughout that legislative history to see how conscious it was. And I think, and I'm working on an article on this, that it reflects the state of Commerce Clause jurisprudence at the time. The cases were later
Wickard and and then Raich and 10 years ago. So
right. So, but I'm thinking the early cases.
Wickard in 44.
Wickard was after. Right. So I think it reflected their understanding of the limits of the Commerce Clause then. But it is very clear, and the courts have said this, it confirmed this, that the way the statute is written, FDA's jurisdiction is triggered if an article ships from one state to another.
And so courts have respected the text of the statute and haven't haven't adopted a more purposeless interpretation of it given the expansion in the Commerce Clause since then?
It is a problem for FDA, and the article I'm working on is called FDA's Interstate Commerce Problem, because it is a problem for FDA because it is narrower than the Commerce Clause jurisprudence.
Oh, okay, thanks.
Okay, good. Well, I think it's time to wrap up the panel, so maybe you'll join me in thanking them.